So the community has figured out that if you want to make advancements in the restoration of the right, it's going to come from the courts. And we're fortunate that we have a Supreme Court that has a pretty good understanding of the right. And if you look at how the Supreme Court has decided these things, and I think that's important for two reasons. One, specifically because you get McDonald in 2010, it takes the Supreme Court 12 years to give you Bruen. And in that interim time, the lower courts all decided, well, we're just going to um, come up with a test that you didn't really articulate at all in Heller, but we're going to do it anyway. And for 12 years, the lower courts just kind of did whatever they wanted. And that resulted in a lot of bad case law coming out of it because they would imply intermediate scrutiny, which is the middle tiered scrutiny if you're counting the three main ones, and almost always found for the government on that ground. So you get Bruen, and Bruen says no, the test is what we said it was, but here it is again, in case you can't read. And they actually said it twice in the opinion, I think, to really reinforce it. You get Heller, which says individual right untethered to militia service, right to keep arms in the home. It does talk about bear as well, and I think it's pretty clear that it also says you do have a right to carry arms for confrontation in public. But apparently, some people didn't get that memo. You get McDonald in 2010 applies the Heller decision to the states. You got to remember Heller was against the District of Columbia, and that's a federal enclave. So now it's applicable. All these lawsuits can be filed against states and local municipalities successfully after McDonald. So that case really opened the floodgates to a ton of litigation. You get Catano, stun guns are protected arms, and then you get Bruen. It says here's the test again, dummies, and there is a right to bear arms outside the home.